Okay, let's dive into a story. It's about a contract that looked totally normal on the surface, but wow, it turned into a 47-point legal nightmare.
I mean, just think about it. You sign a lease for your small business, right? You think you're covered, you're protected. But what if that very piece of paper, the one that's supposed to give you peace of mind, is actually a trap?
Well, that's exactly what happened to one small business. We're going to break down this real-life case where a single retail lease had, get this, 47 different legal problems. And this wasn't some small claims thing. It went all the way up to the Supreme Court.
All right, so where did it all start to go wrong? Well, you might think it was buried in some super complicated legal language, but nope, the problem started with the actual physical document.
The very first red flag was, honestly, you can't make this stuff up. Page 14 of the lease, it was just gone. It literally jumps from page 13 right to page 15.
Now, you might think, okay, a typo, but legally, this is a huge deal. It completely undermines the landlord's case. I mean, if a dispute comes up, how on earth can they enforce a rule that was supposedly on a page that doesn't even exist? That kind of uncertainty, it almost always hurts the person who wrote the contract.
And then you've got the length of the lease. The contract said 3 years. But here's the catch. The law in Victoria, the Retail Leases Act, says it has to be a minimum of 5 years. It's designed to give small businesses some stability. You can go shorter, but only if the tenant signs a specific form, a waiver, saying they understand they're giving up that right. And in this case, yeah, no waiver.
Okay, so the document itself was broken. But it gets worse. When you actually read what was in the contract, you find it's just full of clauses that are straight up illegal.
For example, there was a clause in there that said the tenant had to pay for the landlord's lawyer just to write up the lease in the first place.
Yeah, no. The law is absolutely crystal clear here. A landlord just can't do that. They can't make the tenant pay for those kinds of costs. Any clause that says they can is just poof, it's void, totally unenforceable.
And then there was this doozy. The lease tried to make the tenant responsible for fixing the building's structure. We're talking about the roof, major equipments, the big expensive stuff. It tried to put all of that on the tenant.
But again, the law acts like a shield for tenants here. It protects them from these huge surprise costs. The law says, nope, the landlord is responsible for the bones of the building. So it doesn't matter what the contract says. A clause like that is just invalid, period. So, naturally, the tenant starts asking questions about all this stuff. And remember, there were dozens of other issues too. But did the landlord try to negotiate or clarify things? No. They decided to escalate. They started using this broken lease as a weapon. So, what happens next? The tenant gets this formal letter from the landlord's lawyers. And it makes a really serious accusation. It claims the tenant has just abandoned the property and everything they own inside it. And this wasn't just an accusation, it was a threat. The letter basically said, all your stuff that's left here, we're going to sell it or donate it if you don't come get it by December 22nd. And of course, they put all these really difficult conditions on how it could be collected. Now, this letter was clearly meant to be a knockout punch, right? To end the whole dispute. But there was a massive twist. The lawyers who sent it had no idea about one crucial fact, a fact that changed absolutely everything. Okay, check this out. The lawyers send that threat on December 15th. What they didn't know was that weeks before that, the tenant had already gone to the Supreme Court of Victoria to file for what's called a judicial review. Basically, they were asking the highest court in the state to check if the decision from the lower court was even legally sound to begin with.
So this timeline is the whole ballgame. You see it right there. The landlord is making these aggressive moves based on a decision that was already being challenged in a higher court. That's not just a small oops. That is a huge, huge legal gamble.
You know, this whole situation, using a flawed document, using the legal process itself to pressure someone, it's actually a textbook example of a much bigger problem. It's when the legal system itself gets twisted and used as a tool for intimidation. And there's a name for it, systems abuse. You've got research from places like Monash University that shows exactly how this works, how people can take the very systems that are supposed to protect us, courts, police, all of it, and weaponize them to control or harass someone else. And look, this isn't just something that happens in business fights over a lease. The data shows this tactic pops up in a much more personal and, frankly, much more damaging area, domestic violence cases. For instance, there was this really startling study out of New South Wales. It found that over a decade, while the number of male perpetrators in domestic violence cases went up by 19%, the number of female perpetrators more than doubled. Now, researchers say this isn't because women suddenly became more violent. They link it directly to systems abuse, where abusers file false or retaliatory claims against their victims to manipulate the system.
Okay, so we've walked through this whole crazy story. What's the takeaway for you? Well, it all boils down to one thing. Awareness is your best defense. Sometimes it's your only defense.
So, what can you actually do to make sure your contract is a shield and not a trap? Well, here are 4 things. First, just verify the document. I know it sounds simple, but like we saw, are all the pages even there? Second, know the basic rules of the road, like the minimum lease term in your area. Third, really zero in on any clauses about big costs, like who pays for repairs or legal fees. And finally, and this is the most important one, if anything seems off, get an expert to look at it. You know, these legal protections exist for a reason, but they're no good if you don't know about them.
At the end of the day, a contract is supposed to be a promise of certainty. And I guess the big question this whole case leaves us with is, are you sure yours is keeping that promise?